Welcome back to another episode of the It's Personal podcast. I'm Christopher Adamson, one half of the Adamson Ahdoot partnership, joined today by a couple of our in-house attorneys. We got a real broadcast going on today. To my right is Saad Sweilem or Sweilem?
Sweilem.
Saad Sweilem. Yeah.
Much better than most people get it, so thank you.
Thanks for having me. Saad Sweilem, a recent addition to our firm, as well as Daniel Stefanic, another relatively recent addition to our firm. And as always, we have our super producer, Lauren Henning, on the side. We're back with another episode of the It's Personal podcast. I'm Christopher Adamson.
This is personal injury. It is personal.
Today, we're going to be talking about the criminal justice system, and in particular for these two, their journey from being criminal defense attorneys, public defenders, to now the plaintiff personal injury side of things, so the civil justice side of things. And one thing that I find is I think there's kind of a unifying ethos from like criminal defense, public defenders, criminal defense attorneys, and plaintiff personal injury attorneys in terms of the spirit of representing people, wanting to fight on behalf of people. I think in the criminal justice system, one of the things that we'll get into, and in particular with public defenders, so you guys are representing criminal defendants. For anybody who doesn't know what criminal defense means or public defenders are basically government funded, right? Public defenders, so criminal defense attorneys who are provided to people who a lot of times are indigent, right? They don't have the money to hire like a private criminal defense attorney. So they've been charged with crimes. They don't have the money to hire a private criminal defense attorney, somebody like Johnny Cochran, for example, rest in peace. The whole OJ Dream Team, those guys were all private criminal defense attorneys, and they cost a pretty penny. But most people, especially people who are charged with not white collar crimes, but other crimes, right, like blue collar crimes, let's call them, they don't have the money to be able to afford a Johnny Cochran or an F. Lee Bailey or somebody like that. So if you're indigent, or oftentimes I'm sure they have mental health issues, et cetera, and they get charged with a crime, the state or the federal government will provide them with a public defender. So basically somebody who's paid by the government to provide a criminal defense or zealous criminal defense on behalf of these people. So why don't we start off just by, before we get into your respective bios, kind of what drew each of you to criminal defense and becoming a public defender in the first place?
For me, I was really drawn to being a public defender just from personal experiences growing up. I tell people, growing up as a Muslim kid in this country, when 9/11 happened, I was 13 years old. And it was a scary time for the community. And our community was really vulnerable at the time.
Where was this?
I grew up in the Bay Area.
Mm-hmm.
It's not like I grew up out somewhere where there wasn't, diversity and whatnot. But even here in California, we had really high profile cases. We had in 2006, there was a young man named Hamid Hayat who was arrested, prosecuted, and convicted. In 2006, he spent 14 years in prison out of a 24-year sentence. And just a few years ago, the same judge who presided over his trial threw out the conviction and said that the defense in his case was not good, and the evidence was really weak. But just like you're saying, some communities don't have access to, maybe legal services, or they're not as well connected. There's not as much representation within the legal community. And, I don't want to get into too much about who did represent him or anything like that, or throw them under the bus, but, he actually had representation from the community, but they weren't criminal defense attorneys. So he ended up in a really, in my opinion, in a very, the evidence against him was very flimsy. But he was very vulnerable, came from a Pakistani Muslim family in Lodi. And so they just didn't know how to navigate the system. They just hired, the only attorneys they knew. And next thing you know, he was looking at a 24-year prison sentence. So
What was he charged with?
he was charged with attempting to join a terrorist organization, something along those lines.
Was this like the era when they were going into different, like the FBI was like?
Yes,
Yeah.
yes. So the FBI, that's the other thing that really drew me in is, the FBI was just all over the Muslim community during the whole, 10, 15 years after 9/11. I have really funny experiences with the FBI at my mosque. I remember very, very, very specifically a moment where I went to my own mosque in around 2005, I think. I was around 17, and me and my cousin went to the mosque in Santa Clara. Big community, one of the bigger communities, Muslim communities in America. And we walked in, and there's this white guy we've never seen before. And he just had the whole outfit, he was ready.
Like
he
a
had
windbreaker?
no, not the windbreaker. He had like a whole if you ask ChatGPT draw me a Saudi prince,
Yeah.
it was like
Oh, okay.
yeah, he was ready. That's what he came with. And we walked in, and the first words he said to us were "Assalamu alaikum. My name is Aaron," and we're like, "Oh, wa alaikum assalam." And the next question was, "What do you think about jihad?"
Oh man.
Wait, was this did you watch the Hassan Minhaj stand?
No, I did.
It's that is it that same?
That's not but that's the type of thing that happens,
Yeah.
right? So, and me and my cousin Muhammad, we were literally looked at each other and we're like, "All right, man," and we're like, "Hey, man, jihad just means struggle, That's all we think it means, at least,
Yeah.
So,
Yeah.
and we just walked away.
Yeah.
But that Hassan Minhaj, special. When we see stuff like that, it's important because that's such real experiences we've had, right?
Wait,
So
can you give some context? Because I don't know that story.
Yeah,
about
he's
Hassan
a stand-up
Minhaj.
comedian
Yeah.
who's famous for PowerPoint comedy.
Okay.
And he was telling a similar story of brother Eric, who had infiltrated his mosque, obviously fake undercover,
Yeah.
and he would like hang out with the 13-year-olds at the gym and be like, "What do you think about jihad?"
Yeah.
Yeah.
And they and all into entrap them.
Yeah, and that's based on a true story too that happened in Orange County. There was this guy would undercover agent would target the youth, oftentimes target the most vulnerable, maybe not the most mentally stable, feed them ideas, feed them things, and you take troubled people who are really vulnerable, and you actually end up radicalizing them. The FBI ends up radicalizing them. So for me, a lot of my journey towards being a public defender was just based off those personal experiences. Just there was also we had the biggest charitable organization, Muslim charitable organization in America, the Holy Land 5 Foundation. Same thing happened to them. They're actually still in prison, many of them, again based off of really questionable evidence. And so just those experiences and seeing our community really vulnerable in those situations was really the driving factor for me, and why I really wanted to be a public defender. And I just felt like it was really important to help serve those vulnerable people and navigate a system that's so complex and so intimidating.
What's the Cliff's Notes version of the Holy Land 5?
The Holy Land 5 Foundation was a charitable organization that provided assistance and social services to Muslim countries abroad. They were ultimately charged with aiding and abetting terrorism as well, because they were providing social services in Gaza. And so a lot of those services were in areas that were controlled by Hamas, which is designated as a terrorist organization. And so the legal theory that they were convicted under, to me, is really a stretch, is by providing social services or medical charity, whatever it is, in certain areas controlled by Hamas, they were then aiding and abetting the terrorist organization by doing so. And so, to this day, there's members of that organization that are still in prison. But they actually had one trial. It was a mistrial. And then they had a second trial where a bunch of evidence that was previously excluded was let in because it was considered prejudicial in the first trial. And they were convicted. So, So, I mean, just those experiences are really what kind of pushed me in that direction.
Okay.
Yeah.
Dan Stefanic, how about you?
Well, I should have gone first because it's kind of hard to follow. I woke up one day and just decided I wanted to be a public defender. No, it started when I was a kid. I always wanted to be an attorney. I always wanted to be a trial attorney. I didn't know there was any other type of attorney until later in life. I thought everyone was a trial attorney. And I grew up in I think middle class household, maybe lower middle class. Now that I go back to the neighborhoods where I grew up, and it was kind of a tough. My family was completely dysfunctional, and the kids, my siblings and I, were constantly in trouble, and we all had run-ins with the law over our youth and even into my adulthood a little bit. And a number of times, I saw public defenders providing services for my family members, and I have had public defenders, provide services for me. So when I, started law much later in life and decided I wanted to pursue it, by that point I had kind of made a decision that I had received really high quality services from public defenders who really get a bad rap. And sure, there are a lot of lazy government workers, right? But there are a lot of very good, hardworking public defenders. And I think I really want to give back. And at the same time, I was also told, throughout law school that if you want to be a trial attorney, you go work for a government agency, you go work for the district attorney's office, and you go work for the public defender's office. And by that time, I had a pretty strong beliefs about police and about prosecutors. And that just wasn't for me. And so it was a choice of, well, I'm going to go work for the public defender's office and provide services to people that need services and are facing serious criminal crimes, serious criminal charges. And oftentimes the cases are lacking in support for those criminal charges. And without the service of public defenders, those people would be forced into a plea. And sure, more often than not in the criminal defense world, the prosecutor gets a conviction. But in those instances where the prosecutor is coming at someone without the proper evidence to support the charges, that person deserves someone to stand up for them and say, hey, look, you can't prove that. You can't prove this person did this, right? And protect that person from being forced into prison and jail. That's the long and the short of it is every day people are being forced into prison and jail, forced into taking pleas on charges that they may not have done, right? I think that it's fair to say, a good percentage of people who are charged with crimes probably did commit the crimes, but there are a percentage of people that, in fact, did not commit the crimes, or there's not enough evidence to support that. And those people are entitled to, by the Constitution, entitled to a defense by someone who knows the law and can stand up to the prosecutor and to the state of California. And that was my mission for a long time. And I loved the work. It was great work.
So you felt like you knew from a very young age you wanted to be a trial attorney?
I think when I was probably, 7 or 8 years old, watching Matlock and things like that, I knew that.
Really dating yourself, the Matlock, the original
right,
Matlock,
sure,
not the Kathy Bates Matlock.
And I think I was probably watching reruns as a kid, even then. But sure, any of those shows, To Kill a Mockingbird, Matlock, all those shows. Yeah, were like, that's what I want to do. I like to perform. Yeah, I like to put together a performance. I like to be in front of people talking, although I'm scared shitless of it. And that was for me when I saw it on TV and thought, oh, that's what I want to do. And everyone says, well, it's not like you see on TV. Well, it is. It is like you see on TV. And I love it. So I think that's when it started for me.
What do you think is like it is on TV, the performance aspect?
I think the performance aspect and the kind of gotcha moments, if you find them in your case, and judges coming down on you in court, and even the moments of feeling like you're losing, right? Or feeling like the gotcha moment is against you, right?
Mm-hmm.
I think all of it that you see, sure, TV has to speed the whole thing up a little bit, so maybe it doesn't happen as fast, and there's a lot of behind the scenes work that happens. But in fact, once you get into the trial in front of a jury, it is a lot like what you see on TV.
You're telling a story, you're presenting in the same way. Yeah.
When did you decide you wanted to be a lawyer?
What's funny about that is very late.
Mm-hmm.
I majored in English.
As did I.
Yeah.
English majors.
Did you know you wanted to be an attorney? Or?
I didn't know I wanted to be an attorney. So like it's probably my sophomore year. I remember I sat down with my parents because they're like, let's talk about your future and what we think you're going to do after undergrad, et cetera. And I really had no idea, but my parents always championed education. Like my dad has a PhD. So he got a PhD in accounting from Pepperdine.
Yeah.
My mom has a master's in library science. And so they both always really championed education and prioritized education. And so for me, because I was always a pretty good student, especially in English, I was always a great writer. And so it was kind of like a foregone conclusion that I was going to go to some type of graduate school and get some type of graduate degree. And so we're having this conversation, just talking about my next steps, blah, blah, blah. I remember my dad was like, well, maybe you should consider law school because you like to argue, because he has a Southern accent. Right? Both my parents are from the South.
I didn't know that.
So my dad's from Alabama. My mom was born in Mississippi, raised in Baton Rouge, Louisiana. And so, my dad was like, law school might be a good fit because you like to argue. And I was like, okay, well, maybe that does make sense. And it kind of meshed with my major and my background in reading and writing and reading comprehension, et cetera. So that was really the genesis of it. And so I applied to law school, went to Loyola. But even at Loyola, I didn't know what I wanted to do, what type of lawyer I wanted to be. And to me, unless you go into law school with a real clear idea that I want to do X, law school doesn't really, at least in my experience, kind of direct you towards a particular field of law. They're more concerned about, we're teaching you these classes so you can pass the bar because we want to keep our bar passage rate high so we can attract more students, et cetera. This was back when U.S. News and World Report was still prominent, and they would have the graduate
rankings.
School rankings, the undergrad ranking, and everybody would pay attention to that. Now, not so much, but that's how the law schools keep their rankings high, right? Their bar passage rate, among other things. And so I never took mock trial or trial ad. I never saw myself being a trial attorney, being a public speaker. I was always super introverted growing up. I mean, I still am, but I was very shy, very introverted, did not like talking to people. And so I never thought really that I would be a business owner or that I would be a trial attorney, that I would be speaking in front of people. I never really had that vision. And so when I graduated, passed the bar, started sending out resumes. And then at first I was doing document review by the hour. So I was an hourly contract attorney. They were paying me by the hour to review documents in an intellectual property case. So this was
exhilarating.
Yeah, exactly. This was 05, 06. So back then, back then cell phones were still a relatively new technology. And so there was this big lawsuit between Qualcomm, one of the old cell phone companies, and Broadcom. And so Qualcomm had all these patents on chipsets. So the actual hardware that goes inside your phone, the same way if you took your computer apart, you would see a hard drive and shit like that. In your phone, there's a chipset in there that basically controls the phone because it's basically a mini supercomputer. So Qualcomm had all these patents on chipsets, and then Broadcom basically reverse engineered their technology, and then Qualcomm sued Broadcom for patent infringement. And then I think Broadcom countersued for antitrust because they're you have a monopoly on chipsets. So I was just sitting there it was an internet database of documents, and I would just read these documents, and then I would code them with this is attorney-client, or this is work product, or if it was especially juicy, they're we have a hot doc code that you can use because it's a hot doc. So I was doing that for maybe a year and a half.
It's thousands of documents too, right? You're going one by
just
one.
a big internet database. And so the money was good, but it got pretty boring pretty quick.
Yeah.
And then I started sending out resumes, and ultimately I ended up at a plaintiff employment law firm. So that was really where I got my first taste of civil litigation and representing people against insurance companies, corporations, like same thing we do now in PI, except it was employment law. And
That's actually a good place to, I think, differentiate what civil versus criminal actually means for like the everyday person and when they might be in either of those instances.
yeah, I mean, criminal just basically means your personal freedom is at stake, because like no matter what state you go to, what jurisdiction, et cetera, they're going to have different laws, basically like different codes. So like here in California, we have the penal code. So if somebody's charged with a crime, generally it's under penal code, like 187, as a lot of people know through like music lyrics and movies and stuff like that. Penal code 187 is murder. So that's like a popular one that a lot of people know. 211 is robbery, I think, right? So there's all these penal codes that if you get charged with a crime, so if you got charged with murder, if you got charged with armed robbery, it's under penal code 211. If you get charged with a DUI like 23-152 or something like that, like that's in the vehicle code, I think, actually.
Yeah.
But there's all these codes of conduct that prescribe what you can and can't do as a citizen in a particular jurisdiction. And if you violate that law, allegedly, they'll charge you with a violation of, like, let's say it's armed robbery. You violated penal code 211. The punishment for that is X. So like your freedom is going to be at stake, especially like if it's a felony versus a misdemeanor. So I think the typical distinction, and these guys know better, that we learn in law school between a misdemeanor and a felony is that if you get charged with a crime, the punishment for a misdemeanor is generally 1 year or less, I think, right?
Yeah.
And then if it's a felony, it's 1 year or more. And 1 year in like incarceration, like getting locked up, right? So typically the other differentiation is that if you go to jail, it's generally for a misdemeanor. So jail means like a year or less. Prison means a year or more. So most of the time, like the jails are going to have less violent offenders, people who have been charged and convicted of less violent offenses, or people have been charged but they're awaiting trial. Sometimes they're awaiting trial in jail, I think, right? I mean, you guys could jump in at any time as well, but that's the basic differentiation between like misdemeanor, felony, and then criminal versus civil. So criminal, you're being charged with a crime, and the punishment for that crime is some sort of incarceration generally, or sometimes probation, meaning that you're not incarcerated, but you have a probation that can be, I think it's like non-reporting or reporting, right? So like if you have a probation officer, you have to check in with somebody.
Typically for felonies,
felony.
you have formal probation, and then misdemeanors are informal. Sometimes you have no obligations. Sometimes you have obligations. You got to go to court with progress reports, proof you're doing, whether it's AAs or whatever it is, or like an anti-theft class or, DUI school.
I think one of the real differentiations is if you have a court case where the state's trying to tell you what to do, that's a criminal case.
Yeah.
And everything else is
Full weight of the
civil.
government. Yeah.
So those, I mean, he's right. Those cases are generally like, if you get charged with a crime, it's like the people of the state of California versus John Doe. So it's the government entity, or if it's a federal case, it's like the United States versus such and such. So that's why like a lot of those famous cases too, like the Larry Flint case, for example, back in the day where he got sued by the federal government. I think so. It was like, there was a movie about it too, right?
Yeah.
Starring Woody Harrelson, I think, but it was like, the people versus Larry Flint, or the U.S. versus Larry Flint over like, I think, obscenity laws and stuff like that. But I mean, he's right. Like the framing of the complaint when they formally charge you is going to be the people or the United States or the government or whatever versus so-and-so. And your individual freedom potentially is going to be at stake versus in a civil suit, like what we do, personal injury, for example, or employment law, we're alleging that. So like in our cases, for example, our main cause of action is negligence. So what we're alleging is that somebody had a duty or a responsibility to do something, and then they breached that duty because they fell below the quote unquote standard of care. That standard of care is like, what would a quote unquote reasonable person do in the same situation? So if I'm driving a car and I get rear-ended, the allegation is that this person has a duty to drive as a reasonable and prudent person. They failed to do so because if they didn't, they wouldn't have rear-ended me, right?
Right.
This person's probably like listening to the radio or talking to a friend or dropped something on the floor and took their eyes off the road. And in these cases, the person that we file against, so if I file a suit and it's John Doe versus Jane Roe, Jane Roe is the defendant, and Jane Roe, even though Jane might have violated a duty or breached a duty to drive as a reasonable and prudent person, her freedom's not at stake. It's monetary recourse that we're seeking because the allegation is that John Doe has been physically injured, had to go to medical treatment for his injuries, might have future medical treatment, also might have what we think of as pain and suffering or emotional distress, all as a result of this incident. And
Right.
so we're suing for a monetary recovery against the person who wrongfully acted. Same like in employment law, the allegation in these employment law cases, like when I was doing employment law, so just to backtrack, like in the state of California, there's what's known as the Fair Employment and Housing Act. So under the Fair Employment and Housing Act, there's certain what they call protected classes, which are like age, race, gender, sexual orientation, etc. So you cannot fire somebody because of that protected characteristic. Like if I said, Saad, you're fired because you're Muslim, right? Because there's religious protection
Right.
under the Fair Employment and Housing Act. So in those cases, people would be alleging that their employer took some sort of prescribed action. And as a result of that, they were wrongfully terminated or demoted. The person was wrongfully
Right.
terminated or demoted or something
So
like
you're
that.
going up against mostly corporations.
Typically, so like in personal injury cases, it might be a person. So like if I'm driving and I get rear-ended by somebody, if
But
we
it's at
have
the end
to
of the day,
file
it's their
suit,
insurance company, right? That you're like usually fighting with versus like in this case, we're talking about like the state
Yeah.
public defenders or
but
in
we
court.
know that behind the scenes.
Mm.
But if we actually have to sue somebody, we're suing Jane Doe. We're not suing
Oh,
Progressive
yeah, yeah.
Insurance.
Yeah.
So like in the state of California, also, if a case were to go all the way to trial, we can't even tell the jury about the existence of insurance. They're not allowed to know because the idea is that, and the rationale is that we don't want the jurors' understanding of whether there's insurance or how much insurance there is to
Right.
influence their verdict. Because, you know, if they know that there's X amount of insurance in this case, but Y amount of insurance in another case, the fact they have that information might influence the amount of money they
Gotcha.
award versus what they think is fair compensation for the person's injuries and what the person has been through.
Right.
So, like functionally in our cases, and like John Doe versus Jane Doe, when we sue Jane Doe, she has an insurance company behind the scenes who's actually assigning her attorney. So the insurance company picks the attorney,
Right.
assigns the attorney to the defendant, and then so there's kind of this triumvirate of insurance company, defense attorney, and defendant. So in our cases, like the person that we're suing is the defendant. In a criminal case, the person who's getting charged with the crime is the defendant. So, and we'll talk about this like a little bit later, like in terms of like the crossover between what these guys are doing now and what they used to do. There's a lot of similarity in the ethos between representing an individual, in our cases as a civil plaintiff, and representing somebody as a criminal defendant, as a public defender.
Right. So I guess like I'd love to know from you guys like how do you even prepare to go up against the government? That's terrifying.
You want
I mean, I think that's the whole reason you do the job is
Yeah.
you're the person that wants to be that guy that stands up for someone and goes against the government, right? Sure, it's terrifying at times. I think when you get into really heavier cases where there's a lot of time, a sentence of 25 to life on the line, and there's good evidence against the person, that's terrifying. To go into a trial knowing that the government has good evidence against your client's looking at 25 to life, you know, you're going to be the guy to go in there and do your best to represent him. But at the end of the trial, you're always going to look back and think, oh, I could have also done this, or why didn't I ask this? You know, that it's terrifying to get a guilty verdict and know your client is going away to jail or prison for life and spend your life thinking, oh, what else could I have done? But at the end of the day, at least you did something. You're the person that at least you did something for that person and came in and stood up against the government. And so it is terrifying. And I think it takes a particular type of person that can overcome that type of fear. And also, I guess at the end of the day, it also takes a person who can kind of have a fuck it attitude. You know, I'm just going to go in there and I'm going to do my best for this person. And generally speaking, even if the person gets the guilty verdict, if you've done your best, they're going to come to you and they're going to say, thank you. I know you did your best and stood up for me. And I've had clients time and again that, you know, went down on charges, but just the fact that I came into court for them was more important to them really than whether or not they got a guilty or a not guilty or innocent verdict on the case. Right. And so you just got to, I think it just takes a particular type of person.
Yeah, I would just say it's also very thrilling, you know, like it can be scary. I know it's definitely scary for the defendants, right? They're looking at the, you know, full weight of the government being thrown in the case against them, where, like you said, they're looking at incarceration. You know, they're not looking at their insurance company paying off, you know, for their negligence. But man, it's thrilling. Like being in court every day, being in front of a jury. You know, public defenders are in front of a jury probably more than any other attorney at all in the legal profession.
For sure.
Yeah, and so it's also, you know, in criminal, so much of it comes down to the prosecutor's discretion, right? What charges to file, what charges to pursue, and so because they have that discretion, they often overcharge these cases. And so, you know, being able to sort of be that person who goes in there and fights the government every day, there's just a thrill to that. I think that, you know, really overcomes any fear and you know, any anxiety you might have, because I mean, what could be better than that, right? Like, we're talking about the most powerful government in the world, and you go in there and beat them. It's a thrill. It's really fun. So. And yeah, we take losses too. Everybody takes losses. If you're not taking losses, and you're not doing trials, ultimately, right? But I think that euphoria that comes from winning those cases is unmatched, right?
Well, yeah.
And it's like a special.
You know, we've talked a lot about trial, but also, you know, you got the prosecutor, you got the judge up there in a robe, standing over the court, saying he's impartial or she's impartial, when in fact they're not, right? 100%. And a lot of the biggest moments for myself and my client have been really getting into it with judges that were just acting completely inappropriately or trying to lean on a client that is supposed to be presumed to be innocent, right? And trying to lean on them to take a plea when that's not the job of a judge. So a lot of the thrill that Saad's talking about, and a lot of the satisfaction that we get and the satisfaction that our clients get, have to do with standing up to a judge, even in small hearings or just regular everyday calendar matters. These guys will come in, they're in custody. A judge will try to sit there and tell them, hey, look, if you take this deal today, I'll let you out. You're going to get out, time served. If you just plead to the felony, otherwise you go to trial on this, you could be looking at 15 years. It's not right for a judge to be doing that, right? Mm-hmm. And so you got to, like, standing up to the judges, you're standing up to the prosecutors, and your client is there scared to death all day. He's scared to death in court. He's scared to death in jail. He's scared to death all the time. And his time with you, or his or her time with you, is their only kind of moment where they get to sit and relax, sit back for a minute, and have someone else looking out for them so they can just breathe for a minute. And so I think all of that is the kind of the satisfaction in the job.
Yeah, you find yourself in really weird situations as a public defender, right? Like Daniel's explaining, sometimes you find yourself trying to convince your client to stay in custody a little longer to fight, so we can fight the case, right? And that carrot of freedom, I mean, what more do people want than liberty and freedom, right? When you're in custody, and it's easy as their attorney to be like, look, man, this is weak. This is a weak case. This is not in your interest. You should fight this case, or you should fight this probation violation, whatever it is. And then the prosecutor or the judge, either one, can be saying, hey, just plea now, time served. We'll let you out on probation. It takes a very special individual and defendant to be willing to do that, especially with the exposure, right? If someone's looking at a year, 3 years, 5 years, and someone an authority is
Yeah.
telling them, who they revere, right? We're taught that judges are these authority
Yeah.
figures, respectable, honorable people. And what are we taught about public defenders, right, in media?
Same as
Right.
like personal injury plaintiff.
Yeah,
attorneys
exactly.
that were
There's
basically scumbags.
exactly. It's the same thing,
Yeah.
right? A public defender
Yeah.
is telling you,
For sure.
look, man, you have rights. Yeah, they're going to dangle this carrot in front of you,
Mhm.
but this is a weak case. Don't take this felony. It's a trap. Felony probation is a trap. There's going to be a tail on you.
Mhm.
They're going to, wait for you to sneeze at the
Yeah.
wrong person, and you're looking at prison time anyways. And with personal injury, it's the same thing. The media tries to, or insurance companies have really gone out of their way to paint personal injury attorneys as these sort of like sleazy. They're just in it for money.
Ambulance chasers.
Ambulance chase,
Yeah.
exactly. But it's the same thing. It's like, no, just like a public defender convincing a defendant, hey, assert your rights. You have the right to a trial for a reason, right? You have the right to a trial from peers in your community for a
Yeah.
reason. Don't let this judge decide everything, right? It's the same thing. Someone who's injured, whether it's in a car accident, whether it's, some sort of negligence from a big corporation, they have the right to seek compensation, right? They have the right to be made whole again. It's the same thing. So there's a lot of similarities, I think, where, whether you're a personal injury attorney or a public defender, you're dealing with, vulnerable people.
Yeah. Sure.
You're dealing with people who don't necessarily know how to navigate the legal system, who, really need not just protection, but someone who's going to actually look out for their best interests,
Mhm.
right? In criminal, there's not a lot of people looking out for the defendant's best interests. There really isn't. And in civil, with personal injury, these insurance companies aren't looking out for the person who's been wronged's
Yeah.
interests. They're looking out for their insured and themselves and their pockets, right? So
Yeah.
it's the same thing where on both sides, I think that's where, there's a lot of similarities with the work we're doing here, in that we are looking at for the interest of someone who otherwise, what are they going to have? Who are they going to have helping them?
And I think it's important that in all of these cases, the part of the challenge is we are required to tell our clients what the offer is that's on the
Yeah.
table, right?
Mhm.
And so in
It's
both
true.
cases, you've got people that are in jail, and if you haven't ever been to a jail and
It's also
smelled
true.
a jail
Yeah.
and heard sheriffs yelling at people and seeing people fighting and seeing the food that is served, when a person's offered a deal to get out today,
They're going to take
it's very
Yeah.
tempting, right? And being the person that can persuade someone that no, you need to just hold in there, that takes a particular type of person. And that's the same when you're dealing with, again, we're dealing with a lot of times with indigent people who have been severely injured. And when somebody's dangling $150,000 at them to resolve the case, to them that sounds like, man, that is great money. But to convince them that no, your injuries and the damages and what you've gone through and what you're going to have to go through are worth far more than that, but you're going to have to wait a few years, right? A lot of times civil litigation can drag out,
Mhm.
but if you hold out, there's a good chance you're going to do better than that. It takes a particular person to have that relationship with both of those clients. And I think that's kind of one of the main crossovers in these two types of work, is being that person that has that relationship with your clients.
And the insurance companies know that, right? Like they know that oftentimes our clients are people who $150,000 sounds, life-changing, right? And it may be. But the severity of their injuries, the insurance companies know what they're doing, right? They know that, if this goes to trial, if this goes through litigation, we might be on the hook for a lot more. So, and like you said, they know we have to convey the offer, just like the prosecutor does in a criminal case. That could be frustrating, right? But like Daniel said, I think that's where experience and we're both very experienced.
Mhm.
Obviously, Chris, you have a ton of experience. That pays off quite a bit, I think, because we do know how to talk to our clients and explain this process and kind of just walk them through it.
I think to pull on a couple of threads that you guys have raised during the criminal kind of defense discussion, because I love talking about the criminal justice system or the criminal injustice
Yeah.
system,
Mhm.
right? Because there's so much fertile ground topically. I think, like you guys both mentioned, plea bargains and overcharging. And then I think even to take one step back from that, like, I think in criminal, and you guys can correct me if I'm wrong, but it's a lot more like trial by surprise. I think like in civil cases, we have the ability to do a whole bunch of discovery leading up to the trial. Like we can basically take as many depositions as we want. So like question witnesses under oath in a deposition. We can send a whole bunch of written discovery. Like we can basically be like Sherlock Holmes and try to find out as many facts as we can before trial to line up liability and damages and put on the best trial we possibly can. I think in criminal cases, you don't really have the luxury of having as much discovery prior to going to trial, right? So in a lot of ways, it's like you have one arm tied behind your back, just from a discovery standpoint and being able to prepare your case. And then similar to civil litigation, like whenever we go into a civil trial, we're always behind the eight ball with the jurors because the jurors are just automatically, because of tort reform and advertising and the vilification of personal injury attorneys, et cetera, people just have an inherent bias most of the time against plaintiffs. They think they're lying, they think they're exaggerating, they think they're malingering, or they think, well, even if this person's injured, I got injured and nobody gave me any money. So we're starting out behind the eight ball in plaintiff personal injury cases. Criminal defense cases, even though it's innocent until proven guilty, nobody thinks
Nobody
that.
does
Like,
that, yeah.
every juror, probably like 10 out of 12 jurors are going to think, oh, this person got charged with a crime, so they must have did it. Or the government wouldn't have brought charges or come to trial with these charges unless this person did it. So like all these presumptions of innocence and like people starting off with a fair, unbiased view of the case, like doesn't happen in reality, right? So, but with respect to like discovery, for example, and like not having the luxury of as much discovery in a criminal case as you do in a civil case, is that the case?
I mean, the prosecutors have discovery obligations, Brady obligations in criminal cases where they have to turn over evidence. Now, do all DAs do that? I don't know. I don't think so. But, they have obligations. The big difference is in civil, you can test the evidence before you go in, right? Like you have the depositions, you've got interrogatories, you have all that. In criminal, you have investigators. Investigators go and talk to witnesses. But, the way the law is structured is even in felony cases and preliminary hearings, oftentimes the investigating officer is going to go up there and testify because he can testify to hearsay at the prelim. Because he's permitted to do that because you don't necessarily get to test all the witnesses, see how credible they are. He'll just go through his police report and testify according to that. This person told me this witness told me that. So it's just not the same ability, I think, to test the evidence in civil cases as you do in criminal. You don't have that same ability. What would you say?
Well, I would kind of say, and I think this is a great point that I've learned since coming to civil, and have looked back and thought, you know what, there's a lot of stuff that I maybe would have done differently. And if you're Johnny Cochran, right, and you got all the time in the world to do stuff, then you can drag a criminal case out. If you've got the money to bail your guy out and he's out of custody, and you don't have 100 cases on your caseload today, and you've got access to all the investigators you need, well, then you can show up at that preliminary hearing and you can subpoena 60 witnesses and do the equivalent of taking a deposition of a shit ton of witnesses, right? At the preliminary hearing.
What's the purpose of the prelim hearing?
Well, the preliminary hearing is to determine whether there's probable cause for the charges, whether the person should be held to answer for the charges, right? And so, but you can use that hearing to get testimony from witnesses that you could use, similar to using a deposition transcript later, or to get all of the evidence, get the full picture, right? And if your person's not in custody, then you can put off the preliminary hearing longer and longer. And, you can waive time and put off the preliminary hearing. So a lot of the real trial by fire is our person's in custody. They got no money to be bailed out. And a shout out to the bail project and things of that nature that are kind of starting to come up as nonprofits to try to provide bail to, less fortunate people. And so then your person is in custody and you have one shot at it. And so they bring in an investigating officer. You don't even know about all the witnesses yet. You've been served thousands of pages of discovery probably that you haven't had time to go through to realize, I should be calling these 10 people. You got a preliminary hearing going.
It's-
Some guy's going to come in and say all the magic words to
Yeah.
hold your guy to answer, right?
Yeah.
And that's kind of the end of it.
Who's making the determination? The judge?
The judge is
Okay.
making the
Yeah.
determination, and
You know the phrase you can
Indict a
the
ham sandwich.
Yeah. It's basically
Yeah.
that. Like prelims are the unless there's video evidence, which I've had before, of that your client didn't do it.
Yeah.
They're almost always going to be held to answer, and sometimes the judge will add charges too.
Really?
I could honestly
Sure.
see if you did that, if you brought in witnesses and made the prelim take a while, a judge being like, you know what, man, I'm gonna add this, and that, because you're just gonna make it take really long. Like those
Yeah.
prelims,
well, and that's the risk, right?
that's just the
but,
system, though. Yeah,
But again, if your guy's out of custody, so what if
Yeah.
the judge adds charges, right?
Yeah.
Yeah, it
If
doesn't-
you're getting all the
well-
information you need later for trial,
Yeah.
but the other problem is you can't establish the elements of another crime during a prelim, and the prosecutor can add charges,
yeah.
the judge can add charges.
could even increase bail after
Yeah.
adding the charges,
Yeah.
so they could be like, yeah, you're out now.
Yeah.
You're out of custody now, but guess what? I added these charges. Well, now your bail's this much. So sheriffs take them and they got to bail out all over again. Is the criminal justice system is really fascinating in how we don't realize it comes down to really discretion by human beings just like us,
Yeah.
who have authority, who have the ability to make these really horrible decisions. And, man, like when people are having a bad day,
That's true.
sometimes
For
they're
sure.
unfair.
Yeah.
And I would see that with judges.
Misplaced anger.
Yeah, I would
Yeah.
see that with judges where one day my judge is in a great mood and feeling very lenient,
Yeah.
and then a week later my poor client just has him on a bad day, and
Yeah.
he's getting remanded into
Yeah.
custody for the
Yeah.
exact same thing that last week was not that big of a problem. And so it's just, I think that's ultimately, I think, the biggest difference between civil and criminal is, I love as a personal injury attorney now, feeling like I have all the weapons. There's no hand tied behind my
Yeah.
back. It's a level playing field. It's not always an uphill battle.
Mhm.
It's not always trying to put out fires,
Mhm.
right? We get to call the shots. We get to be aggressive. We get to, fight a fair fight
Mhm.
in civil. That's ultimately what I appreciate about it, I think.
I remember I was listening to a podcast, I think probably 5 years ago at this point, about, I think it was the criminal justice system in Cleveland, and they were talking about overcharging and plea bargaining, et cetera, which I think probably happens in every state, every jurisdiction.
Yeah.
So basically the prosecution or the judge is going to overcharge somebody in terms of so if you commit a crime, it might be okay, we could charge you with this crime for sure, but we can also charge you with this crime and this crime, which carry more time. It might be harder to meet the elements of this crime to convict you of it, but we're going to charge you with these other crimes that carry more time to basically force you into taking
Just
the
the
plea
risk,
bargain.
yeah.
Because it's it's the risk. It's because that podcast that I mentioned, they were talking about if every criminal defendant actually exercised their right to go to trial in that venue, the whole system would collapse. There wouldn't be enough prosecutors, criminal defense attorneys,
Would fall
public
apart.
defenders, judges, et cetera. We don't even have the manpower to handle the volume of everybody who's charged with a crime. So in order to alleviate that, we have a plea bargain system that's basically predicated on overcharging people who are in a vulnerable position. Oftentimes this disproportionately affects people of color, poor people, et cetera. So we're going to overcharge you with something to leverage you into taking a plea bargain, because now if you know that, the maximum I could be facing is 25 years, but they're offering me a plea bargain of 1 year, even if I know I'm innocent, completely innocent. There's been lots of people historically that have been completely innocent, but they'll take a plea bargain just to avoid the prospect of getting hit with real jail time or prison time. So I just think that's one of the failings of the criminal justice system. I'm sure these guys have seen it on the front lines, but we even saw it recently in the ASAP Rocky trial, because they were charging him. He was facing 24 years. They offered him a plea bargain of 6 months, and he turned it down. But kind of back to your point, he had the luxury of time,
Yeah. Out of custody.
money. He's
Yeah.
out of custody. He can afford the best attorneys. And so ultimately it worked out for him. But for the vast majority of people, it's not going to work out, and they're going to capitulate to taking a plea deal because they're facing so much time.
So who's benefiting from, like, how is the government benefiting from overcharging and over incarcerating people?
Well, you see all the time with the governor and the states, every state talking about their conviction rates, and that, you know, there's a lot of federal funding, I think, and a lot of state funding based on what your conviction rates are. And luckily, LA County has reciprocity, but, you know, the DAs, meaning the public defenders, are supposed to get paid the same as the DAs. But the DA's whole budget is based on the number of convictions that they're getting, right? And so if you want more money, you get more convictions.
So the incentive built into all of this
But
is to convict.
It's all about the money, man.
I also think like it's important to acknowledge that historically, you know, the government tends to throw people in jail when they don't have a solution for a problem, right?
Yeah.
And right now, you know, homelessness and mental health are just huge, and drug addiction, substance abuse, are huge problems. They're huge problems that our community is dealing with, and unfortunately, that's usually the answer for these kinds of problems is, well, can't put them somewhere else. Oh, they don't want help. They won't accept help. Truth is, there's not as many resources and services available that you would hope, and oftentimes the answer is, well, let's arrest them and put them in custody. One thing I wanted to just point out real quick about being in custody versus out of custody that's important is people don't realize when you're in custody and you're going to trial, you're waking up at 3 or 4 a.m. every single day to get on a bus, to be driven to the jail, to sit outside on the bus until the court opens, to come in, sit there all day, mostly in shackles, except when you're in a court, you know. And then afterwards, you don't get back to the jail probably till, you know, 8, 9 p.m. You've had a peanut butter jelly sandwich the whole day. And then you got to wake up at 3 a.m. the next day and do it again, right? Yeah. And so like Daniel's talking about, when you're out of custody and you're going home every day, sleeping in your bed, eating dinner with your family, right? And then you wake up the next morning, 7:30, 8 a.m., drive to court, you know, it's completely different experience. And I think that's why the bail reform is so important, is people don't understand the different levels of disparate treatment that people who are poor and can't afford bail, how it affects them. It's like that. It's really, that's why it's so hard to convince people in custody to do a trial. Yeah, because it's not just the exposure. It's always like, man, like this is really hard. Like, who wants to wake up at 3 a.m. 5, 6, 7 days in a row, just to be treated like an animal too? You know, it's not like you're getting up 3 a.m. like sometimes we might have to do for work or whatever. It's just to be treated so poorly, and then I don't know. It's really hard. So I just wanted to point that out because I don't think people understand the practical part of it as well. It's really hard to convince someone to do that.
Well, also when they come into court for a trial, they come into a room full of people who look at them, and the look in their eyes is like, why are we here? Like, why are you putting us through this? We all know you're guilty, right? In a civil case, it's a little different. You're coming in, and sometimes they're skeptical of the attorneys, but as they hear the story, you know, they don't come in with the case already fully decided. In a criminal case, I would say 95% of the people show up at the courthouse and have already decided the case before they've even heard the name of the case or seen anyone in the case.
Yeah, that's how I would start my voir dire. I would say, you know, so how many of you walked in and saw Mr. So-and-so and thought to yourself, I wonder what he did? And everybody raises their hand because that's just how it is, right? Like, people just don't quite understand this system, how messed up it is. So that presumption of innocence you're talking about, it's really our job when we were doing it to actually bring that presumption into the courtroom, because it doesn't arrive with the jurors. You have to sort of build that wall. And so I would tell them, I'd say, well, you're all wrong. You know, you could be driving down the highway and see someone getting arrested and wonder, oh, I wonder what he did. But you're not driving down the highway. You're in a court of law. And when you look at him, the only thing you should be thinking is, oh, there's an innocent guy sitting at the table, you know? So
well, I think especially like to that same point, a lot of those people, when they come in, when you're like, look at Mr. So-and-so. How many of you have prejudged Mr. So-and-so? It's also because Mr. So-and-so looks like their stereotypical preconception of what a criminal looks like. It's like a black or brown person. They might look a certain way. They might have tattoos, etc. But like that programming is very pernicious. Like that's one of the things that's why I have like a love-hate relationship with Law and Order, actually, because especially like if you watch some of those old seasons, like in the 90s, they use some pretty pejorative and like disrespectful language about black people a lot, about brown people as well. But like I remember there's one episode where they're talking about Harlem, and like one of the cops refers to like pipeheads in Harlem, which, Harlem is like all black people, maybe not now, but especially back then. So there was like, and they had a lot of criminal defendants on that show who were black, right? And so that's not just entertainment. Like people watch that and then it becomes ingrained in their mind, like, okay, this is what a criminal looks like. Yeah. And so, because like in the vast majority of these cases where these guys were public defenders, it's not like when they show up, you see somebody at the criminal defense table in a suit who's like looking like Dan, Like most of these people, they look like what the stereotypical perception or what the jurors think a criminal looks like. And so you have to fight, like they have to fight against that ingrained prejudice. Like I think that's a big issue. Kind of getting back to your question about incentives and like who wins with like a plea bargain system. Like he mentioned, there's incentives behind conviction rates and shit like that. But then also, even aside from that, because if you talk about who wins, like the fact that we have a plea bargain system where like the vast majority of cases can get pleaded out means we're not going to overload the criminal justice system with all these people going to trial, because then the system would collapse on itself. So that doesn't happen. But then even maybe more perniciously, there's the whole private prison industrial complex at this point. So those people win as well, because you're keeping those prisons, their coffers full, like you're keeping them full of people, and then those beds are worth a certain amount of money at 90% capacity or whatever. I mean, it's a private enterprise. Like I'm sure there's regulations around how they're supposed to be run, capacity issues, stuff like that. But there's nothing illegal at this point, at least, about having a for-profit prison, which is what that I think it was a Netflix documentary, the 13th Amendment, right? Yeah. That's all that was about. So I would recommend anybody watch that documentary because it's very elucidating. But I think that's probably like the biggest driver at this point in terms of convictions and what the incentives are, because it's for-profit prison institutions. I mean, these guys might have more to say about that, or more relevant.
I think California did away with them, right, Daniel?
I'm not sure. I'm not sure if it is or not.
But I know that's definitely a problem, like nationwide.
Yeah. Chris brought up a good point, and I know we're going to talk about why Saad and I decided to leave the public defender's office at some point, and this is another good point that Chris brings up. You grow up, you watch this TV, you see these criminals, right, and another thing you're fighting in court in the criminal system is what's called confirmation bias and expectation bias, right? And those things are created by exactly what Chris just talked about. You've seen these things, and you think, I'm getting called in for this criminal case. I bet it's going to be a black guy or a Hispanic guy. And you get there and you see a black guy or Hispanic guy, and you've made up your mind. And that's that expectation bias. Or you get there and you start hearing charges, and they're similar to all the charges you've seen on TV that people are being prosecuted for and convicted of. And then all of a sudden your confirmation bias kicks in, and the judges, the prosecutors, the state, all those are big beasts to go against. But going against somebody's bias that have been created in their own mind and trying to convince them, but also teach them to actually set those things aside is nearly impossible. That's the biggest beast you're up against in a criminal case, really, is the beliefs that people have created in their own mind, whether knowingly or unknowingly.
Yeah, and I think the real difficult part of that is who wants to admit they have those biases, right? Like who's going to want to be like, yeah, this guy's right. When I came in here, I assumed I was going to see a minority being accused of this kind of crime, and here we are, right? It's really hard, but it's really important. Yeah. And I think in civil too, though, it's the same thing. Like race, comes into play just as much. I think, for a plaintiff, that's still a conversation you're going to have with the jury and voir dire on is an issue like that, right? So there's a lot of parallels, and those implicit biases people have. I think the best way to confront them is just head on in jury selection, because if you're too afraid to do that in jury selection, then man, you're really setting up those biases to just come down against you real hard.
Yeah.
Because one thing I do notice is when you do that, what I felt like, especially in criminal, and when I would do that, is they have to go back and deliberate with 10 other people, right? Mm-hmm. If I've done that, then they're going to be probably less willing to say some things as that they would say as a result of their implicit bias, because I've hit it on the head. Yeah. They're going to be thinking, oh, I'm not going to say that in front of these other people, So you at least get that. So there's just a lot of different ways I think it comes out to play. But
I think it's one of the most important things for attorneys to be thinking about how they're going to approach in voir dire, because it takes a very delicate approach, right? You got to really kind of establish a relationship with the jurors, and then kind of bait them into accidentally admitting that they have these things going on. And then it's almost like cross-examining someone on the stand, right? You got to get these people to admit this thing that they would never admit knowingly.
Yeah.
The only way they're going to admit it is accidentally. And then you got to still be delicate, because you want to ask the rest of the people in the room also, hey, anybody else feel the same way, right? You really, if you have a whole room full of people that have these type of bias, which generally you do, then you've got a whole room of people that should be excused for cause, really.
Yeah.
And so you need to find that, right?
And I feel like you always got that one guy who's like a dingus and is just like, yeah, I'm racist. Like he's just trying to get off the jury, But I actually love having those people, because I never want to have, like, I'd rather he tell me that he doesn't want to be a juror, right?
Yeah.
So like, I know he's BSing, he's just trying to get off the panel, but those people are great, because then you're not pulling it out of someone, and all you have to be like is like, look, you make that person the hero, right? You make, like, look at how brave he is. Room full of 70 people, and he's telling us, he's a piece of shit, but like, we should celebrate this guy. He's saying he's racist, he has these biases. Like, your honesty is so amazing and important, and that's why we're all here. Who agrees with him, or who maybe doesn't agree to the extent that he's talked about? Maybe he's a little out there, but who still has some of the same biases, right? So you kind of just use that person as a tool to okay, now let's use him to weed out who else is a bad juror.
Yeah.
So I have jury duty in 2 weeks. I've never been to jury duty.
Which courthouse, do you know?
The one near the airport.
That could be criminal, right?
It is criminal.
It is criminal.
That's criminal.
So my dream is to be on a murder jury.
Just remember to vote not guilty. That's all.
You just talked about an expectation bias. When you say my dream is to be on a murder jury,
I want to be the foreman.
You should have no thoughts about the case that you're going to.
So I'm already
and then
out.
when you get there and you hear it's a murder jury, what happens next in your mind?
Ooh, this is exciting.
Yeah. I don't know.
Huh.
I watched the show Jury Duty, so it's about my only.
People have so many ideas and conceptions and misconceptions about what it's like to be on a jury, or what's going to happen in a trial. Like, one of the other things that happens is, like, I think a few years ago, or maybe like 10 or 15 years ago, they came up with this term, the CSI effect, because they think every case is going to be like, you can draw a line from like A to Z. All these dominoes are going to fall. All the dots are going to connect.
Right.
And then it's going to become very evident this person did or didn't do it. Right. But it's not like that. And so, especially like in criminal cases, like the vast majority of these cases are circumstantial evidence cases. Like, no matter how much evidence you have, the reason a case is going to trial is because the criminal defendant isn't like, oh, hey, I'm guilty, I did it. Right? They're saying they didn't do it, and now the case is going to trial. So you have to take all these pieces and try to connect these dots based on this circumstantial evidence. Like, if you were to take the OJ case, it's like, oh, we found this bloody glove, then we found this bloody sock, we found this evidence at this location, we found this evidence at that location. So you're taking all this circumstantial evidence, like evidence of the circumstances of what happened, trying to piece it together and tell a story. But because of shows like CSI or Law and Order or any of those procedural type shows, people have an expectation that they're going to show up to trial. The attorneys are going to do boom, boom, boom. There's going to be this big aha moment, and then everything's going to be made clear. And now there's going to be a righteous verdict, right? But it's not like that. Like on the criminal side or the civil side, oftentimes we have to fight against that. I feel like it's probably actually, I would say more uphill for the prosecution in criminal cases with the CSI effect, because if you're an adept criminal defense attorney, you can use that against them and say, hey, they're saying that this is what happened, but there's a hole here, there's a hole here, there's a hole here. Like they haven't pieced together all the circumstantial evidence to be able to warrant a conviction. So I think like with any of these biases, there's ways to like turn them on their head and use them to our advantage, whether we're doing criminal defense or civil.
100%. And in criminal, you can do that. You can say, well, did they get any DNA? They could have gotten DNA.
Reasonable doubt right there.
They could have made you an animation. Now, Saad says reasonable doubt right there, and that's the argument. But the problem with a lot of these shows is I think a lot of the shows have lowered the burden to more likely than not, right? So you got the OJ case, you got the bloody sock, you got the bloody glove, you got picture OJ in this place at some time. Well, he frequents, but you got a bunch of circumstantial evidence. Is it more likely than not that the guy did? Well, probably. But is there a reasonable doubt, right, is the question that it's very hard to teach a criminal jury how to approach, because what a reasonable doubt is easily becomes, it probably was, or more likely than not. And so the burden has been lowered by these shows, and it's very hard to hold a criminal jury to the burden that they're required to meet.
Which is it's a super high burden, beyond a reasonable doubt. Like, imagine if you think about what that really means. Like you have the prosecution has the burden of proof, and they have to prove this thing happened beyond a reasonable doubt. Like if you really think about it, that's a very high bar.
I was going to say, and the nature of the charge is really important too, because I can get up there and talk about a reasonable doubt, and the jury could be like, you know what, he's right. Beyond a reasonable doubt, this guy didn't steal the Snickers from 7-Eleven, right? Yeah. But when you're up there, it's like, look, he did not kill this guy. Beyond a reason, it's a lot. They're gonna, if they feel more likely than not, he did it.
Yeah.
They're gonna be a lot less inclined to be like, he's right. This wasn't proven beyond a reasonable doubt. So it also comes down to that too, the nature of the charge. And that's what's kind of scary though. It's like the more serious charges oftentimes are, sort of ironically the ones that lead to convictions on flimsier evidence. Like you'll win some misdemeanor trials that you had no business winning based off the reasonable doubt argument. And you'll lose some heartbreaking felony cases with the same argument, with a lot flimsier evidence that are really, genuinely don't think the evidence is there. So that is an interesting part of the system.
So how does one be a good jury member?
Be a good jury member?
I told you vote not guilty. If it's a criminal case, you vote not guilty.
You got to empty your mind of everything, really. Like, that's what's in the best interest, not just of the plaintiff, but also the defendant or the prosecution and the defense in a criminal case. We're not asking for a biased jury in our favor in either situation, in civil cases or criminal cases, much as like we might want to joke about that. But all we want is a fair trial for the criminal defendant and for our civil plaintiffs. So that's the best way to be a good jury member, is to really come in with a completely open mind. Whatever inherent biases and prejudices you have that you're aware of, set them aside. Like, people have a lot of implicit biases and prejudices that they're not even aware of. But that's why it's incumbent upon us as the trial attorneys to even try to suss out those implicit biases through our questioning. But I mean, the best thing you can do as anybody who's called to jury duty, first of all, thank you for your service if you're actually showing up, right? Because there's a lot of people that'll just take that notice and throw it in the trash. They don't feel this duty as a civic duty is important enough for me to miss work or whatever obligations I have to even come to trial and show up in the first place, or show up for as part of the veneer. So all those people who do show up, like, kudos to them. We appreciate them. And then the second step is emptying your mind of whatever preconceived notions you have about criminal cases, civil cases, getting rid of all that stuff, and just be open to only hearing the evidence and deciding the case on the evidence that you hear, not deciding the case based on what you think your mom might think of the case, or your dad, or your husband, or your wife. Like, you can't be influenced by any outside pressures, not even the judge. Because at the end of the day, like, the judges should only be there to call balls and strikes. But it's the evidence that comes from, like, if this is the witness stand, if he's on the witness stand, whatever he says on the witness stand, assuming like nobody makes an objection and it's admissible evidence, that's all you can consider, or a document that actually gets admitted into evidence. So you have to be able to, like, drown out all the outside noise as well, and only listen to the evidence and pay attention to the evidence, which admittedly is a hard thing to do, but that's why it's so important for people to take their jury service seriously in that respect.
I would say one thing too, I think that's important to be a good juror, is when you go back in the deliberation room, it's holding the other jurors accountable,
That
right?
too.
Because oftentimes what you find with juries when you talk to them afterwards is there'll be one or two or three people who did all the talking, and everyone else is just like, man, whatever, you know? So you need to make sure everyone's actually following the law, actually holding the burden, right? Upholding them to the prosecutor, for example, if it's a criminal case, to their burden. And then if you're especially in a criminal case, I say, if you're a standalone, if you're that person saying, I don't know, I don't have proof beyond a reasonable doubt, and everyone else is like, no, this is it. Just let's go home. We don't want to come back on Monday. It's Friday. We're done deliberating.
Move about 12 Angry Men.
Yeah, right. So it's you standing firm and saying, no, there's not enough. So I think that's really the most important part of a juror, is just not folding to the peer pressure of everyone else around you. Because most people will just be like, man, come on, let's just get out of here,
They're going to go along to get along.
Yeah, exactly.
Can you guys be on a jury?
Yeah. Sure.
I mean, if we get called, it depends on if they'll have us. But typically,
Right.
as soon as you say, I'm an attorney, they're like, we don't want this guy.
Yeah.
Plaintiff or defense, or like prosecution and criminal defense. Like, it doesn't matter. Like, most of the time, they don't want attorneys because they think the attorneys are automatically going to be the foreperson. Because unless there's another attorney on the jury panel, which is like probably astronomically low, the odds of that, having two attorneys on one panel. So if you're one attorney out of the 12 people, they're automatically, like, when you go back to the deliberations, everybody's going to look at you and be like, you're the foreperson, tell us what to do. Even if you don't even do, like, you can be a bankruptcy attorney and it's a criminal defense case, and they're going to be like, what should we do? Like, you understand this stuff. And so most of the time, like, attorneys don't want other attorneys on the panel for that reason. They're just going to be like too smarty pants, or they're going to be like trying the case themselves in their mind, like, oh, you should have objected there, or this evidence shouldn't be admissible. And so it's just, most attorneys think it's hard for other attorneys to kind of set that aside.
Yeah,
I would say.
So Chris and Saad talked about how to be a good juror. Once the evidence starts, once you're in the deliberation room, I think that the way you're a good juror is by being a good juror when you walk into the courtroom, right? And that requires, like Chris had, set aside your biases and your preconceived notions, but that's almost impossible to do. So I think be aware of them. And every step of the case, through voir dire, through hearing the evidence, ask yourself, wait, am I evaluating this through the lens of my biases, or am I evaluating this through a clearer lens, right? Are those biases affecting the way you're looking at the evidence? But also be honest. Go in there, be humble, be honest. Treat it as a safe space, even though it could be really embarrassing. And if you're sitting there and they're asking questions and you think to yourself, well, I kind of have that, but I think I can set it aside and be fair. Say that out loud to the person asking the questions, right? Tell them, I'm sitting here, I'm thinking I kind of have that, but I think I can set it aside and be fair. And you're helping the other potential jurors as well, because you're giving that attorney an opportunity to ask you questions to decide whether you're actually the right person for the jury. But you're also helping people that are too scared to say anything to now have the opportunity to say, I agree. Like, I agree. I have that also a little bit, but I think I can set it aside and be fair. And that's how you end up with an actually fair, what's potentially as close to a fair panel as you can get, is by people coming in and being honest and overcoming the fear of speaking in front of a room of 50 other people, right? You got to say whatever it is that would be an unpopular opinion. You have to say that in front of 50 other people, but that's the place where this person that we're talking about that's in custody being oppressed by the government and by the county and waking up at 3 a.m., he deserves to have you come in and give him a fair trial, right? He or she, I say he, I'm sorry. The person coming in a criminal trial that you're going to be at deserves a fair trial and deserves that you do everything you can to make sure that that person gets a fair trial. And so I think that that's really the most important place.
I'm gonna rock
I think the point about being honest, that's a very important point that bears like reiteration, because I think for good trial attorneys, like, I don't care what you say, I could take it. I would much prefer you be very open and honest with whatever your opinion is and not worry about hurting my feelings, because I have to know this information in order to zealously advocate on behalf of my client. So like, I prefer you be as open and honest with me as possible. I don't care what it is. Like, I can take it, but just put it, like, say it out loud, put it out in the ether versus just holding it in here. Because if you're holding it in here and I don't know it, it's going to affect my ability to be able to put on the best case for my client.
And I think every trial attorney functions that way.
Every good one, yeah.
But every potential juror doesn't function that way, and that's what we need. We need the jurors to be like, okay, this guy, like that, this, I'm not gonna, even if I do offend this guy, it's my job to say what I need to say.
Yeah, and that's why when someone finally does it, you just really need to make them seem
latch
like,
onto it.
Yeah,
man.
you just really uplift them. It's really funny. Like, someone will say something that everyone in the room will be like, oh my God, he said that to him. This guy's going to be pissed. And I'll just be like, wow, like, your honesty is exactly why we're here and exactly what we need. And you just uplift that person. And because you want to pull out everyone who thinks like him. You want to know who they are, because them having those negative thoughts about your case, about you, about your client, it does you no good if you don't know about it. Like, you're not... If you know about it, it does you real good because you're going to get them off your jury. So it's funny that you asked about, like, can we be on the jury? Because there's some really funny horror stories about either DAs who ended up on a jury or public defenders who ended up on a jury in a criminal case. And it's just because, the other attorney didn't ask him questions to be able to get out that, oh, yeah, this is a public defender or this is a criminal defense attorney. So anyone could really be on a jury. I mean, if you could say you could be fair and impartial, you could be on the jury. There might be conflicts, I think, if like you're from the same office. But yeah, there's some really funny stories about public defenders ending up on juries that I've heard over the years. So it could definitely happen.
I think at the end of the day, voir dire is all about building rapport.
Yeah.
Not to necessarily get off on like a voir dire tangent, but we were talking about it. And that's really what your job is as an attorney in voir dire. You're trying to build a rapport with the people on the veneer panel as well as you can. So kind of to his point, if somebody's like, oh, I think all black people are criminals. Like, whoa, why would you say that? That's racist. Like, if you react like that as an attorney, you're going to shut down everybody. Like, people are going to be afraid to speak, even if they agree that was an outrageous thing to say. If you react in a way that's very defensive or making them feel like they're wrong, you're going to shut down everybody. And like, you probably don't know, but when it's time for voir dire, the judges they're calling up like 40, 50 people. So there's going to be like, let's say 40 people that are in kind of like the audience section. Yeah. In the galley or the gallery, whatever it is. And then, there's going to be like 12 people that get called up that are actually sat in the jury box. So even though I might be questioning these 12 people here, the rest of the people in the veneer are still in the courtroom. So they can hear all the questions and answers. They can hear what I say. They can hear what other people say. So like if somebody says something that I might think is super wild and I react to it, not only do the people I'm questioning see it, but everybody else sees it as well. And they're like, oh, this guy doesn't really want to hear what we have to say. So even if somebody says, like kind of to his point, they say something that's like off-putting or that you didn't expect or whatever, it's like, oh, I appreciate you telling me that. It might be a little bit difficult for me to hear because of who I represent, but I appreciate the fact you let me know. Is there anyone else who feels, like Miss Henning or Mr. Stefanic or whatever? And then is there anyone else who feels the way Mr. Stefanic feels? You raise your own hand and then get people comfortable with raising their hand, because you always want to position yourself as the leader, even though the jurors are the ones that you're ultimately empowering. But for the time that you're in front of them, questioning them, the time that you're up there presenting your case, like, you're the leader in that courtroom. They have to look at you as such. And in order to really build that tribe and have them see you as that, you have to be building rapport, which comes through like a variety of factors. But one of those factors is like not diminishing how they feel or denigrating how they feel. You have to make them feel appreciated, supported, no matter what they say, which is genuinely how I feel. Like, I want people to be as honest and forthright with me as possible, because that's what I'm there to do. That's what I'm there to elicit. So to me, that's what I'm 100% of the time. Like, I appreciate that stuff.
Yeah, nobody wants to be judged, right? So when they say something, you gotta react. You gotta be very accepting, almost like you almost have to act like you're not shocked at all.
Exactly.
Right?
You have to rationalize it sometimes, right?
Sure.
Right.
And that's how you play it out to get more people to raise their hands, right?
Yes.
And Chris brings up you asking people to raise their hands. And I typically ask people to raise their hands, and you get a couple different situations. You get people that raise their hands and you write down their numbers, right? You're going to come back and talk to them, or no one raises their hands. In either event, the first people I go to are the people that didn't raise their hands. And I ask them, how do you feel about, what Mr. Adamson just said, or did that trigger anything for you? Right. Because a lot of times someone is sitting here hearing someone say something and thinking, like, why the hell is this guy saying this? Why would anyone ever say this
out loud?
Even though they have the exact same view.
Yeah.
Right. And they're never going to stand up and admit it until you pull it out of them.
Yeah.
So.
Yeah, like what you said, right? Like, if someone said that, just think if someone said, "Oh, I don't like black people," and my client was black, the first thing I'd do is rationalize it. I'd be like, well, I really appreciate you saying that. And for a lot of us, our personal experiences just create these biases that we just can't overcome. Mm-hmm. And the hardest thing to do is to be honest about those biases. And you doing that in front of all these people is really commendable. And then you just use him to instead of, because if you fight him, no one else who has those biases is going to be honest.
Any biases.
Yeah, or any, because no one's going to want to fight with you. No one's there. They already hate that they're there. They hate, So that's why it's really, that's the fun thing about trial. Like, it's just, you're on your feet. You're very quick. These things happen. And if the more you do, the better you get at it. But you're able to think, okay, how am I going to use this to my benefit, right? When you're a really young attorney and someone says something to you like that, you just kind of panic and you're just like, oh my God, I'm not asking this guy any more questions, right? Because you're just like, oh my God, like now everyone's going to be like, think like this guy, right? I don't want him to poison the jury, right? Yeah. So, but as you gain more experience, you realize, no, these people I use to my benefit and I use them to see who else I need to get the heck off this jury. So it's fun. It's a lot of fun. I had a juror tell me he was older white guy. Told me he was the essentially creator of the TSA. And I couldn't help myself. I was like, oh, this is awkward. And he was just stone faced. But everybody was laughing, but he was stone. But I was like, okay, I definitely don't want this guy. Because I also wanted to see how he would respond, because I was like, oh, this is awkward. And he's just stone faced. I was like, oh, sorry, I've just had interesting experiences with TSA. Stone faced, right? So I was like, okay, this guy's not, he doesn't think this is funny.
He's not your target audience.
Yeah, he's not, right? But then I'm also paying attention to okay, who are the jurors that laughed?
Yeah.
Because I'm ingratiating myself with those people, right? I'm developing that relationship with them where later on I'm going to be really serious and I'm going to be saying some things and, they don't hate me. This guy definitely hates me, right? So it's just, jury selection I think is probably the most stressful initially because who wants to get up in front of 70 strangers and begin the process of trying to convince them that, hey, you should believe what I say as opposed to what this other probably really smart, talented person says, right? But it's probably the most important, I think, because if you suck at jury selection and jurors don't like you, and you're not able to like I said, sort of figure out which jurors are good and bad, then your case is doomed. If people hate you, they're just not going to want to give you anything, right? They're not going to want to agree with you. They're not going to listen to you when you tell them, look out for this, this, and that. But if they like you and you guide them through it, like this witness is going to come up and I want you to pay attention to this. This witness is going to come up. This expert's going to come say this. If they like you, they'll listen to you.
Yeah.
And when that witness comes up, they'll actually look for what you're telling them to look for. So, but at the same time, like you said, you want them to see you as a leader, right? Someone they respect. So it's a delicate balance when you're trying to ingratiate yourself with them.
It's also the only time that we get to talk to the jurors directly and have them talk back.
Yeah.
So
Do you not get the monologue at the end?
So we get opening statement, closing argument, but if I'm giving an opening statement, I can't have a conversation with you. Or if I'm giving closing argument, I can't have a conversation with you. Voir dire is the only time we can actually have a two-way conversation with the jurors. So that's why it's even like doubly important to make sure you're building rapport with the jurors when you're doing jury selection, because it's really our only time to engage with you on a two-way street.
And every jury in there is checking boxes for or against you, right? And they're gonna use those boxes later on against your client.
Yep.
And in a criminal matter, there's only two ways to use the boxes. There's guilty or not guilty. In civil, it's a little different. You could have a person with a really valid injury that they deserve compensation for, and those boxes can be used against that client later on when the jury goes back and decides what the damages are, right? So you got to be really careful about establishing rapport with the jury, establishing a relationship, and at the same time not offending. You don't want to end up with anyone on your jury that you've offended. That's the reality of it.
Yeah.
Is you don't want to end up with anyone that you've offended. So it's
very delicate balance.
I think one final note before we kind of segue into what led you guys into the civil side is with respect to juries, criminal versus civil. In a criminal case, the verdict has to be unanimous, right? And so it's even more important in a criminal case to try to build rapport with the individuals on the jury, because all it takes is one to have a hung jury. And kind of like what he was saying earlier, if somebody, let's say there's 12 people in that deliberation room and there's one holdout, if you've given that person like the resolve to continue being a holdout in the face of what these other 11 people are saying, that can mean, freedom versus incarceration for your client. Because if there's a hung jury, now I think the state has to go back and think about if they want to try the case all over again, et cetera.
Well, that is the other thing. When you have a loser, when you have a loser case in criminal, you're looking for that one relationship on the jury or two people that you connect with in jury selection that you think you can convince to hold out, right? That's the equivalent of the state overcharging. That's you finding the people to hone in on to create a hung jury for the state to be in the position to either have to make a lower offer or try the case again.
It's a lot of resources that goes into putting a trial together, right? And so you're taking up a courtroom too, which everybody hates. Like everyone is just frustrated because you're taking up a courtroom. So if you get that hang on a really bad case, you're usually going to get a much better offer.
That's right.
Afterwards, because they're going to be like, man, we're not going to do this again. Bring all these witnesses again. So you'll usually get a better offer. Man, there's nothing more beautiful than a hang on a dead case. Where that one person is just like, no. Not beyond a reasonable doubt.
And with a retrial in criminal, you have gotten into the situation where now you have prior testimony and you have, right, and and a lot of impeachment evidence. The retrial is a lot riskier for the prosecution, and so you have created a situation that is beneficial to your client.
I actually had a case before in my career where my client was facing a charge that was not immigration safe, which meant that he risked deportation if he got convicted, and we got to hang 11-1, and they give him an immigration safe offer after that because they were like, we're not going to do this again because it was a low level offense, stupid offense. it was a soliciting case, and you know, it's like everyone else is getting offers. This guy's not getting a diversion or anything, but they ended up giving him an immigration safe offer after that. So it makes a difference. That's why being a good juror is so important.
So what prompted you to make the switch from criminal to civil?
For me, a lot of it was the criminal justice system is so broken in so many ways. As much as there are parallels in both you're fighting for the little guy, so to speak, you're helping the vulnerable. I just love how much more empowering it is to be in civil, where, like I said, it's more of a level playing field. I'm not, so worried about judicial discretion or prosecutorial discretion. I don't have to beg the DA for leniency. I don't have to be like, give this guy another shot. I don't have to worry about cases being overcharged. I just love the fact that in civil, not only are we representing the little guy, but we're able to dictate the playing field, right? We get to decide what causes of action we want to pursue. We get to be aggressive. We don't have to be worried about a judge or a DA, getting upset because we're being aggressive and using their discretion to hurt us. That was honestly for me the biggest thing is the sort of freedom that comes with civil and being a plaintiff side attorney, especially, to just kind of be the best, most aggressive attorney you can be. So that was a big thing for me.
I think for me that, there was a number of things. The first were everything we talked about. It's draining on the attorneys to also go through the heartbreak with these clients over and over again, right? I mean, clearly the more important person is the client, but it is draining to day in and day out, go through this type of heartbreak with people. And then the caseloads are just so high. And for me, like I said, I came in it a little later and I'm looking around the office and seeing people that have made an entire career out of it and their lives are miserable. Their lives are pretty much miserable, right? And I guess at some point you got to, a lot of people are in it for the cause for their whole life, but you also have to be concerned about your own health and about, your own happiness. And there's a lot of bureaucracy in government work and a lot of, coming in and grinding out 12, 15-hour days. Well, 90% of the office is coming in for 2 hours a day. So there's a lot of seeing that. And then for me, I think it also came down to, I had a lot of student loans and I was looking at, do I want to make a career out of this, or do I kind of had the opportunity to stop. I hadn't accumulated any interest yet, and I could go kind of make a better living and get everything paid off and put myself into a better situation for retirement. And so that was a factor for me. But also, I had always wanted to be involved in police misconduct cases, right? And that's where there's kind of a crossover between criminal defense and really just standing up for these people versus taking action for these people, right? And that's kind of the situation that, I think I picture kind of a crossover of kind of handling both those types of things in the future. If I want, when the opportunity presents itself, and we've kind of had that come up a little bit. But I think that's the difference is there's these particular areas of law where I wanted to go from the role of standing up for people to the role of, being the aggressor for someone and getting out there and kind of handling stuff. And so I think that was a lot of the motivation for me. I think that the government wrongs people and those people needed a defense, but at the same time, somebody has to hold the government accountable as well.
One thing I just want to add is in both instances, right, as a public defender or as doing, civil now, personal injury, you're often meeting people at really their lowest points, right? In criminal, you're meeting someone who's probably just had the worst day of their life. And in this field as well, you're meeting someone who's been through something very traumatic and is now injured, right? Have serious injuries. And in criminal defense, it's you're really trying to put the fires out, right? And it's a whole process where every day you're meeting, say 10, 20, 30 people who had the worst day of their life, and you're not going to be able to fix the problem, right? What I really appreciated about civil and being plaintiff side is, my whole job is to make you feel whole again. Sometimes it's not going to be possible, and that's unfortunate, but I know that when you leave us, you're going to be in a better position, better footing, right? And I think there's just something fulfilling about that. Is both of them are very fulfilling. Don't get me wrong, but there is something especially fulfilling of knowing, like, okay, I actually do feel like I'm making a difference here for this person's life. In criminal, like Daniel was talking about, one of the most heartbreaking things is, as good of a job as you do, oftentimes the person you help is right back in custody a couple weeks later, 3 weeks later, just because the root of their problem, of their trauma, is not being actually acknowledged, right? And the criminal justice system's just not designed to solve that. But I think in civil, what I appreciate is, although it is, a monetary system we're talking about, with that money comes treatment, comes services, comes doctors and rehab and physical therapy, whatever it is, that does actually help people with their problems. So I think that's also something I'm really appreciating, as well as when it comes to the differences.
So in terms of making the switch, and we've talked about the experience a little bit, but what are 2 or 3 of the things you enjoy the most about the civil side?
Well, I mean, getting to work with you, Chris, is the best thing. No.
That goes without saying.
I think that there's a lot more, I guess, autonomy or room to kind of work my own hours. And I'm a person who loves, I love really early morning. And then when I want to really put the time in, I love really early morning to really late at night. And I like the ability to do that. I think I also really enjoy the idea of having a team, right?
Yeah.
And in the public defender's office, you're working for yourself. You don't really have a team. They don't have the resources. Having, like Saad was saying, having the resources at your disposal to really try to help someone and then learn how to use those resources is really, it's a great feeling. And I've also really enjoyed the opportunity of learning new legal skills that really I never would have acquired. And in fact, if I ever did go back to criminal or back, I would now approach those things differently based on the skills that I've acquired here. And I think that that's what I really am all about, is like doing new things and getting new skills and learning how to use those new skills in new ways, right? But and there are things that I miss about the criminal defense. I miss being in court every day.
Yeah.
I love being in court every day, doing court stuff every day, dealing with judges every day, fighting with prosecutors every day, feeling like I was, having to be on my feet all the time. I loved all those things, but I think I really enjoy the civil side.
It's like a previous relationship where you remember all the good stuff, and then you sit there and you remember all the bad stuff. But no, I've sort of touched on it already. I love the fact that some district attorney doesn't have
control.
the control to call the shots. It's just so frustrating, right? Because sometimes you got a cool DA who's gonna be fair and listen to what you have to say. Other times you've got just this person who grew up in an affluent community, just looking down on everybody. I love not having to deal with that BS anymore. Like, I can't emphasize that enough. That's the biggest thing for me is when I go to court now, I'm not worried about the judge doing anything. I'm not worried about having to convince the DA to look at my client as a human being, So I love the level playing field. Like, it's such a difference maker. And it honestly, it says a lot about how broken our criminal justice system is. that's the one thing that really stands out to me. But it is like I can't deny that. It's honestly liberating in some ways as an attorney to just be like, okay, I've got the tools, I've got the skills, I've got the experience, and now I'm not, being held back by a system that's just so unfair, right? So, I mean, obviously our civil system's not perfect, but it's great. I think it's great that it gives our clients, the opportunity to seek their justice, right? So,
and I think that Saad brings up a good point. When I was coming over into civil, people pointed out, oh, it's far more contentious and it's a lot more work, and there's a lot more writing, right? Yeah. There's a lot more depositions. And it is, I think, at times more contentious.
Sure.
But it's a different type of contention. It's contention about money, and in the public defender or in criminal defense, when you're going up against these prosecuting agencies, and I won't, some are worse than others. But the reality is you are going up against people who think they are doing the work of God.
Yeah.
And it is the most frustrating experience to have to deal with those people that literally believe that that's what they're doing. They're here doing the work of God, putting these people in jail or prison, and you're never going to change their mind, right? And so
those are the true believers.
Yeah.
True believers,
if you're lucky, you come across a few that are very reasonable and will listen to the logic and will review the cases, but most of the prosecutors are coming into the case thinking the fact that they've got a case in their hands means the fact that they've got means they've got a guilty guy in their hand, right?
Yes.
And they're not even going to look at that evidence.
Yeah, I was going to just say, you have the true believers in civil too, who are acting like the insurance company's policies, their money, like it's going to come out of their personal bank account, but it's different. It is different. It's different when that person doesn't get to call the shots and say, well, this is it, this is the offer, take it or leave it, or go to trial and face way more, right? So that's what I just love about it. It's like, I mean, most I think defense attorneys in civil aren't like that. They're pretty easy to work with, talk to. They understand, we're both going to be aggressive and do our job. But when you do come across the true believers, it's like, okay, let's go then. It's not like in criminal where oftentimes the true believers take the worst cases and the worst. They take advantage of the worst opportunity, right? So, I think that's a great point from Daniel. And, he didn't want to name agencies, but. The Los Angeles City's Attorney's Office can
just the worst.
Yeah, they just
just the worst. Prosecuting municipal code violations and little tiny misdemeanor petty thefts as though they're the worst felony ever committed.
Yeah,
I had a guy once for charged. That Department 47. He was charged with I think eliciting a tow or something like that. Like he had a tow truck, I guess, and he saw someone and said, "Hey, do you want a tow?"
Really?
They charged him criminally. Yeah, he was. I had a hookah shop owner charged with a crime for food and hookah in the same spot.
Why? Because you didn't have the proper license or something?
I think you can't serve food and hookah indoor.
Oh, okay.
I mean, I'm not saying I do that, but I'm going to bring him to criminal court for it. I don't know.
Before we start to wrap up, I just wanted to ask, and you can answer this too, Chris. What's one case or one trial that's really stuck with you in a good or bad way?
Criminal or civil?
Either.
And I just had this, when I left the office, I had this murder case that it's one of the very few cases I had that I am convinced that the defendant did not do it, that my client did not do it. The evidence, I'm convinced he didn't do it, and even more so, I am convinced that if he did do it, there is no way to prove that case beyond a reasonable doubt. And there were just too many other people involved, and there were other people with motive and opportunity, and I just went and watched the trial recently, and he was convicted on it, and it's one of those cases that it's going to really tug at me for a while. And I'm in contact with his family, and I'm, really hoping to be helpful on the appeal, because I am convinced that this person did not commit this crime. And I think that's the one case that stands out in my mind. All of my other cases, I've had a lot where I thought, I don't think they did it, right? Or, this just doesn't seem, it's not adding up for me. But this one particular case just really, it was hard for me to leave behind, and I haven't entirely left it behind, I guess.
We talked about this one.
Yeah.
I think my favorite case, I'll keep it lighter, is I have this case where we went to trial, where I had a unhoused individual who was very mentally ill, and a vehicle was driving by, and he had like this big metal rod, and he just boom, hit the window, broke the window on the car. And like the police show up, it's on body worn, and he's got the rod in his hand. And the guy's like, "That's the guy who hit my car." And we had to go to trial because he was on felony probation. So if he was convicted, he was looking at a lot of time. And so we had to go to trial because they wouldn't make an offer that didn't have a conviction. And a conviction is an automatic probation violation. There was this small segment. I was watching the body worn. There was hours of body worn. There was a small segment where he says, "Hey man, that guy was messing with my stuff." So I was like, "There's our defense, defense of property."
Yeah.
And if you look at the video, like the stuff is literally a pile of trash.
Yeah.
And I remember this because it was Christmas Eve. It was when we got I think we got 2 days before Christmas. I think the 23rd we got the verdict. Not guilty. and it was, I always laugh at that case because I'm just like, that's an example though of, okay, stupid case. Why are we here? It's a vandalism. This guy's mentally ill. He needs help. He doesn't need jail, it was just, I always laugh at that case because, when you look at the video, like the stuff he's talking about is trash. Like this guy was clearly just driving down the road and this poor guy. So
one man's trash is another man's treasure, though.
Literally, my opening statement. My opening statement was, it doesn't matter if you live in the Beverly Hills in your mansion or if you live in the streets in Skid Row.
Yeah.
One man's trash is another man's treasure.
Yeah.
And my client had every right to defend his property as he would if he lived in a mansion in Beverly Hills. And 12 people agreed with me, man. So,
I mean,
that's my favorite, though.
I think with what we do, and I've been doing this since 2010 when Alan and I partnered up. I mean, the cases that stick with us the most are the ones that are the most heartbreaking. Like the ones that stick with me the most are the ones that are the most heartbreaking. And oftentimes those are death cases. And so we posted recently about this case on our socials, the Christian Navarro case. That was the name of the decedent, but the young football player who suffered severe heat exertion, heat stroke, and ultimately passed away at 15, 16 years old. So that was a tough case just because personally for me, I grew up playing football for 10 years. I've been in those circumstances, where you're working out with your team and it's quote unquote hell week and the coaches are really putting you through your paces. And so for me, like personally, it hit home. And then also just to see kind of the fallout and the devastation that it wrought on the family. That was a tough case. So, especially because like in those kinds of cases, it's like, there's no amount of money that can compensate, two parents for the loss of their son. There's no amount of money that can compensate somebody for the loss of a life. So regardless of how much money we're able to recover, you're never going to be able to fill that void and fill that one. 100%, like the family members in those cases, they would pay any amount of money for this not to have happened. So that's kind of how like I think about those cases and quote unquote how I value those. Like those cases are priceless in the sense that there's no amount of money that can compensate for what's been taken away. And so those are the ones that really stick with me. But that was a very impactful case.
And in this job, we have a case coming up right now kind of with those circumstances. And it has been by far the most memorable case I've worked on here, but I am currently working on it, but it will always stick in my mind. And one of the most memorable things about this case is getting to meet the mother of the victim and establishing a relationship with her and just being so inspired by her, by how she has recovered from this loss and by her outlook on life. And it really, I found myself in the last months since meeting her a number of times kind of feeling sorry for myself about something or maybe thinking, oh God, I'm burnt out and I don't want to do something or whatnot. And thinking about her and how she got through this experience and became the person that she is today with the attitude that she has. And it has just been the most touching and inspirational thing that I've experienced, I think, in my whole legal career, probably. So, but those are the ones that stick out, I think, in this job.
Yeah.
You know,
I agree with kind of your last point, though. Like, because of what we do, we also meet some of the most resilient people just by virtue of what we do, whether it's family members who have lost a loved one or people whose physicality, like their injuries, have altered them for the rest of their life, but their ability to kind of rebound and be resilient and keep a stiff upper lip and like work through some of these traumas, like, it's definitely kind of, I think, a testament to the human experience. And like he said, there might be days where I'm feeling like down on myself or like, oh, I can't believe this thing happened. But then these cases also help put things in perspective in a way that's like, okay, what I'm upset about or frustrated about is very minuscule and minor compared to some of the losses that our clients have endured. This stuff, I think we're going to close this out and then come back with a little lighter pop culture segment, but it was a great discussion today. Any final thoughts?
Fun to talk to you guys, man. It's always a pleasure.
Yeah, I agree.
No, thank you for the opportunity. Thanks for having us. And I don't know if we really followed the plan or not, but it was a great conversation. I felt like it was a great conversation, and we talked about a lot of important stuff. So thank you.
This podcast is brought to you by Adamson Ahdoot, LLP. Hosted by Christopher Adamson. Produced by Lauren Henning and Chris Weigen. If you have thoughts or suggestions, email us at itspersonal@aa.law. The views, opinions, and statements expressed by guests on this podcast represent the personal perspectives of the individual speakers and do not constitute official positions of Adamson Ahdoot, LLP, or its attorneys, staff, or affiliates. Nothing discussed creates an attorney-client relationship, and the content is provided for general informational and educational purposes only. Always consult with a qualified attorney about your specific circumstances.